Aloha, everybody. I'm Eva Andrade. I'm here with Marcus Oshiro, Faith and Family First, on the show where we're going to talk about all the things that the Supreme Court of the United States has been doing over the last few weeks. And it has been phenomenal. Win after win after win, depending on what side of the aisle you're on. Maybe it's loss after loss after loss. But let's chat about that.
Depends on what side you're on.
That's what I'm saying.
Because there's two sides to every Supreme Court decision.
There is. On our side, it's been win after win after win after win.
For the most part. Because you have a 6-3 majority.
Yeah.
Let's call a spade a spade.
Can we be rejoiceful for once, Marcus, though, as a faith-based organization?
You can. Hey, you know what? Things can change, so you better enjoy it now.
We've had our tail kicked for a number of years. And to be honest, I am tired of my bruised okole.
Well, you've had some pretty big wins, okay? So,
well, okay, there's been a lot.
Okay,
there's been a lot. So we'll do. And as a retired attorney,
yes,
we have to remind people that you were not licensed to practice today.
I'm not, and I'm not practicing law.
And you're not practicing law. So we are just having a discussion.
Yes.
So let's have a discussion about all of these court cases today. So actually, let's do this first. There was a case that just got decided on July 8th. And this was Trump versus American Federation of Government Employees. And this is where the Supreme Court granted emergency stay of a nationwide preliminary injunction that was issued on May 22nd by the Northern District of California, which had blocked the Trump administration's massive federal workforce reduction plan. So this was basically Trump wanted to fire a whole bunch of people.
Yeah. I think he went over like 17 different departments and agencies. Just wholesale layoffs, reduction in force, with the assistance of Mr. Doge himself, Elon Musk. Yeah.
Yeah, and surprisingly, the Supreme Court came back and basically, and I think it was a decision that was pretty narrow.
It was.
But basically gave him permission to do what he needs to do.
Yeah, I think that's the sum and substance of it, that they would not enjoin the executive order on the termination, layoffs, and changes. Seeing that the executive branch, Article 2 powers, reside with the president to make these changes. The litigation can continue as far as the appropriateness of it, but it's not ripe for the Supreme Court to weigh in at this time.
You made a very good point, because my notes say that it's a temporary, non-final decision.
Yeah, on that issue, yeah.
Yeah, so it's not like they just said, okay, go ahead and do what you're going to do forever, right? I mean, this is just, it was narrow about specific.
And I think the criticism that would come up right now is that, okay, now you have this reprieve, have the legislature, Congress, go back in and examine all of these changes by the executive branch. If you disagree with it, you have the power of the pen, you have the power of the purse. Mm-hmm. Make the changes.
Right. So that's where we're at right now.
And I'm a strong proponent of the legislative branch being the most powerful branch. So use the power. And
it should be, because the people
use the power that you have, and correct it. You can override the president, right, by changing the law.
Yep.
So it's in your court.
And actually, it's good, because right now what's happening on that particular case is that the Ninth Circuit now, which is us, which is why I wanted to talk about that first, they're going to review the merits of the injunction. And depending on whatever that outcome is, either party may petition SCOTUS for full review via certiorari. Is that the word?
Yeah.
So whatever that means, certiorari. Right. And if it's denied, the current stay remains only until that denial. If granted, the stay continues until SCOTUS renders its final opinion. So that's where we're at right now. Right. So that's an interesting
Well, there's another big one that I think came out today. It was a settlement agreement at the
IRS?
Federal District Court.
Yes.
And, one of the district courts in Texas.
Yes, Tyler, Texas.
They entered into a settlement agreement, and they put it forward for the judge to basically say that for the pulpit, churches and our ministers and our pastors, they can engage in the regular service they provide to their flock, their congregation, their members. And even if it talks about some of the ongoing politics in that jurisdiction, or even nationally, locally, that doesn't run afoul of the Johnson Amendment.
Well, here, okay, so
And that's a big deal.
it is a huge big, because that's one of the things we've been teaching over the years is what pastors can and cannot do, right? Based on the IRS
Right.
specifications.
Right,
So
right.
now that the
For the
IRS
501c3
for the
standard.
501c3, right?
Right.
So now that kind of does make it different for churches. But can we talk about the elephant in the room? Because I think that as a faith-based organization, we have to look at both sides of this, right? So the win is a freedom of speech, right? Nobody,
Yes.
there's been a long-standing argument that the government should not go into a church and tell a pastor what they can and cannot preach from the pulpit.
I agree.
And me
think,
too.
I think that's a First Amendment freedom of religion.
It absolutely is.
Right.
But the elephant in the room that I want you to consider this now, just as a listener,
Yeah.
as a viewer. Here's where the problem comes in. So let's talk about Calvary churches, because I want to pick on Calvary, because I could pick on the Catholics, but let's pick on Calvary just because it's a big church, a big group. So you have one Calvary pastor who says you got to vote for this candidate A because, and then they tell all their congregation why candidate A is the right person. And then down the street, Calvary B says you got to vote for candidate B because, and they give you all the reasons. To me, well, first of all, if they're preaching gospel values, that shouldn't happen. So I want to throw that out there, because I don't want to get the email from the person go, if you're preaching the gospel, you're not going to have that issue. But remember that human beings are pastors.
Right.
Which means that we have good pastors, and
I think they even notwithstanding this ruling that seems favorable, they need to be very circumspect and thoughtful on what and how they preach the gospel. That it doesn't have the unintended
on any topic.
Doesn't have the unintended
Yeah.
consequence of expansive influence upon other people's political choices.
Right.
You can talk about values, mores,
And that actually should be
and that's
what they do.
That's basic, right?
Because what you're doing is you're equipping your congregation to be able to go into the voting booth and make the right decision based on these biblical values and principles.
Right. And most people do.
That's what you should do. Rather than saying vote A, vote B, because you tell people, and we saw this happen in many elections. I could use many examples, but I won't, because I don't want to send people on bunny trails. But the point is that you could support a candidate this time and tell everybody to vote for that candidate, and then they get into office and they're suddenly not doing anything that you asked them to do.
Yeah, I think you need to be hypersensitive to that effect, and to be overly cautious, and to be more conservative in those kind of pronouncements. But I think the ruling today kind of makes it clear that the IRS standards regarding 501c3 church-related activities,
It was because of the freedom of speech.
Right.
I mean, I don't want the government telling pastors what they can preach from the pulpit, period.
Yeah.
I don't want the government telling doctors what they can and cannot do in their practice, which is what happened with the licensed professionals on counseling. I don't like that.
That's another SCOTUS, Supreme Court of the United States decision that we can talk about later.
Yes. So that's what I'm saying. So there have been some good ones. All right. So let's go down now with some of the other ones. All right. So let's talk about United States versus Rahimi. And this is the gun ownership and domestic violence.
Right.
And this was SCOTUS upheld a federal law barring people under domestic violence restraining orders from owning guns. I say amen.
I would say amen, amen. It was a 8-1 decision. I think Justice Thomas was the dissenting, and he dissented quite strongly because he was the author of that New York gun club case several years ago, I think the Bruin case, that basically created a fundamental right under Article 2 to have unrestrained ownership privileges of a gun, unless there was some historical reference to the late 1800s restricting the possession and use of a firearm.
Oh, Jim Hochberg is all about that case.
Oh yeah, I know that.
Yes.
I know that.
Yeah.
Yeah.
So let's be honest, and
Yeah,
and
but-
there we have viewers and listeners that probably are not going to be happy
They
with
will
this
not be.
ruling.
They will
So
not-
this is not going to be a win to some of our people.
Yeah, but it was a
Yeah.
8-1 decision. So let's get real. On the current composition of the court,
T-
and you got the so-called conservative ring of the Supreme Court with the Chief Justice,
Mm-hmm.
right? Amy Coney Barrett, who are more moderate,
Yeah. Yeah.
right?
Yeah.
You got and you got Miss Jackson on board, and
Yes.
right?
I-
I mean Justice Jackson.
To me, I because
yes,
my mom's family's from Missouri. They were all gun owners, right? And responsible gun owners. And so, of course, they're very strong Second Amendment people. But I was born and raised in Hawaii where it wasn't an issue for us, right? So I kind of look at it different. But to me, I was just looking at this issue. If somebody has been convicted of domestic violence, they have no business.
well, this is even before that. I think this is where rub some people the wrong way, is that this is if you get a civil order of a restraining order. You apply for a restraining order, you go down to the court, and you get you get one ex parte. You filing upon your affidavit, you get a restraining order. From the time that restraining order is served upon the individual to be restrained, it goes into effect.
So that
And-
means someone who hasn't been convicted, just
That's
someone
right.
who's been okay. So I can see then
Yeah,
where people would be, wait,
yeah.
that's not a good thing.
But I think given the balancing that goes on here of the dangers, and it's a temporary limitation on ownership possession versus the possibility of injury or taking of one's life, I think on balance, you got to go that direction. And I think that's the decision. We'll see what happens, going out. But I think it was a strong decision by the United States Supreme Court.
Well, if you're watching or listening right now, I'm curious to what you think. Write it below in a comment. Because you can totally disagree. Because I honestly, like I said, I was looking at this through the eyes of someone who has been convicted of domestic violence. I would not want someone like that owning a gun. But if the situation is, as you mentioned, where it's just a restraining order, then I can see how people might be upset about that. I want to know what you think.
Yeah, this guy was a gentleman in Texas. He had a firearm. He was witnessed by beating up his girlfriend or whatever like that. He went after the witness. He tried to shoot the witness. I mean,
so the case that it was built on was
no, the facts were astounding. Like this guy
that should not have a gun.
Should not have a gun. This guy should not possess. He gives gun owners a bad name because he was so reckless in how he used the weapon. So it gave legitimate, law-abiding gun owners a black eye. So you don't want these kind of guys.
Yeah, I agree with you.
Yeah,
on
and
that
right
one,
now he's serving time in jail.
as he should.
Yeah, I think he got a 5-year or 6 years term.
What one of these days we'll have our buddy Jim Hochberg on and get his thoughts on
Okay.
these gun cases because obviously
Well, as long as he's a hunter in New York or in Florida, right?
yeah, exactly.
Yeah.
Exactly.
Yeah.
All right. So the second case is Moyle versus United States. And this one was the emergency abortion care versus state pro-life protections. And so the summary on this one is the court dismissed the case on procedural grounds. No clear ruling on whether federal EMTALA law overrides Idaho abortion ban.
Yeah, this is a case that's unusually procedurally, because I think this is the one the United States Supreme Court itself dismissed the case for improvidently taking the certiorari and accepting the case for a hearing. I think, all of them agreed that they shouldn't have heard the case in the first instance because the facts hadn't evolved to the place that it's appropriate for the court to pronounce its review of the case. So they dismissed it even after the oral arguments. So that was quite extraordinary, but they didn't want to weigh on this case. And I guess it boils down to the federal law that was created to prevent patient dumping. And to make sure that anyone receiving any kind of federal monies, Medicare or Medicaid monies, will accept and treat and stabilize anyone getting into the emergency department. That's the law if you take federal monies. Now the question was whether or not that went up to and including any kind of abortive services, because in Idaho there is a stringent requirement of very narrow abortion services allowed. Right, I think it was for incest or rape, and then for the life of the mother. But that you could have a person coming in pregnant but needing some medical care, indigent, and part of the services to help this person, stabilize this person, may involve some surgical procedures, medicinal procedures on their reproductive organs.
So would you say that this is a win for the faith-based community, a loss, or is it just something that's kind of now in holding?
I think it's one to wait and see, because there are still cases, I believe, going on in Texas. I don't know if it's in Tennessee or Georgia, Idaho, of course, because the case was sent back down to the trial courts, district courts. But it's going to come up at some point in time. You know, what happens with these state laws prohibiting abortion? And these are all, post.
Oh, yeah.
Right. So we don't know yet,
Yeah.
right? And then you have this
Yeah.
EMTALA, which is Emergency Medical Treatment and Labor Act in place, which has a good idea to make sure that people are properly serviced and life extending, saving, services are provided, regardless of ability to pay, runs smack into a prohibition against abortion, except for those limited instances. Right?
Okay. Well, that's another one to watch then.
Yeah.
Okay. Now, how about Murphy versus Missouri? And this is the one, free speech and government influence. This is a social media case, right? So SCOTUS ruled the plaintiffs lacked standing to sue, leaving questions about federal influence over big tech content moderation unresolved.
My honest opinion, it's a bad decision. I had wished that they would have weighed on it. What's interesting about that, Murphy, I think, was the former head of the, was it Food and Drug or National? Yeah, I think Food and Drug. I think the prior secretary or the agency head, and that state was one of two states that challenged it, because the states felt that it infringed upon their citizens' right of First Amendment right to get information. Interestingly, two of the plaintiffs in this Murphy case one is Jay Bhattacharya, who is now the head of the National Institutes of Health.
Oh, interesting.
The other guy
I didn't make that connection.
Dr. Macquarie, who is now the head of the Federal Food and Drug Administration. So they were plaintiffs because they felt that their voices, their opinions, and a lot of it regarded the COVID-19 limitations that was imposed by Collins and Fauci, and that group didn't make sense. They were contrary to what they believed in, but they were squelched in the social media realm with, what was it, Instagram and Facebook.
There was a lot of that going on.
Yeah,
yes.
But the Supreme Court said there wasn't enough proof, there wasn't enough connectivity, cause, and effect upon these individuals, so that they dismissed the case.
Yeah. Okay, I agree with you then.
But it's scary because it still stands for in my opinion, that government can somewhat nudge a social media company to go and squelch, prevent, shut off.
I tell you what,
someone's free speech now. So we got to watch this.
Did you read the book 1984?
I did.
Way back? You got to read it again. I read it again, and I was like, I swear some of these authors were prophetic.
Roberta Thomas, Little High School English class. We studied
we had to read it in high school too.
1984.
Thinking, wow. And I remember
along with Animal Farm too.
I remember at the time thinking, no way are we ever going to have the thought police and all this. But we do, man. This is
it's like Michael Jackson. I'm bad.
Exactly. Shimon. Yeah. All right. How about Trump versus the United States? And this is the one about presidential immunity. So SCOTUS rules that a former president has some immunity for official acts, but not for unofficial ones.
Yeah, that's the question: is what is unofficial? What is
Right.
official? I mean, unofficial is
Even Stevie Wonder should be able to answer that question. I find it hard to. How can you get confused over what's an official act and unofficial act? Have we gotten to the point now? Yes, we have. I answered my own question. We have gotten to that point. So, how do you think this is going to impact future presidents?
Well, I think as we're seeing right now in Trump's second and final term, you're going to see how far he's going to take this. What kind of actions is
Not
going
if
to
you believe some. If you believe some, he would have a third term.
It's going to be up to, by definition, right? You know what I mean? What is official? What is unofficial? And that kind of got grayed a little bit.
It's very gray.
Yeah.
Yeah, that is sad. Well, I think it's going to set a dangerous precedent, but that's just me.
That's what we need to be aware of now. Whatever pronouncement the Supreme Court of the United States makes upon this president at this day and age, unless they go back and change their minds, like the Dodge decision, right? Roe v. Wade, right? It remains the law of the land until the next Supreme Court changes.
The checks and balances. So last week we talked about the legislative powers, and now we're talking about the judicial powers. Maybe next week we should talk about the third check and balance. All right. So the next case is the Free Speech Coalition versus Paxton.
Oh, yeah.
And this is the pornography age verification law. And so SCOTUS allows Texas to enforce its law requiring age verification for porn sites, declining to block the law.
Yeah, I think that makes sense today. I think the technologies have greatly improved from the 2020s when Congress passed, laws back then to prohibit, minors from accessing pornographic websites. I think the concern back then when the Supreme Court looked at it was there wasn't the sufficient technology, the streamlined technology to sort out minors accessing these porn sites, and they would have been over-inclusive and maybe also create some danger on access to the information, data, credit of those people going through the system. So they struck it down. And Congress never picked it up for 20 years until Texas, in its legislative wisdom, came up with this law. So I think there are about 20-something states that have a similar law in place.
And where does Hawaii stand?
I'm not sure. But it makes sense, right?
So this might be, so if Hawaii doesn't have anything on the books, this might be something for a legislator to pick up and introduce a bill and have us, be because why would anybody want to support, our youth having access to pornography?
And I'm thinking that maybe
underage.
And normally, I think in a normal instance, I'm just going to share this. I think one of those things that maybe the Progressive Women Caucus might want to pick up if they see that pornographic material, videos, etc., are exploitive of women. I mean, there's men and women engaged in the industry, but primarily, I think the actors are women, right?
Back in the early days, you might remember this. When Kelly Rosati was the executive director of Hawaii Family Forum, she was a big fighter about the pornographic materials that were at our public libraries. Do you remember that?
I remember that.
Virginia Isbell, I think, was the...
Virginia.
Was the one Kelly had to work with. But, back then, there wasn't as much pushback. So Kelly was able to get a lot done, and because it was a reasonable thing, to require that our youth be protected against this kind of materials.
I think we should. I think it makes sense to me. So I'm pleased with the decision of the Supreme Court. There's somewhat concern on the First Amendment freedom side that this could also expand government's overreach. Again, into other areas, if I think along the logic behind it, right?
Are we moving to the land of Oz where he's behind the curtain?
No, it's to protect, the community, in this case, young minors and that constituency. But there could be other sources of information, so-called misinformation, or different non-medical based advice that comes across the YouTube.
We're gonna be
that can hurt people.
We're gonna be consistent, Marcus. We're gonna say we don't want youth to access pornography. We don't want youth to access marijuana. We don't want youth to access gambling.
I don't think it's good. So I think this decision itself on what they did and the findings they have for the Texas law makes sense.
Okay, well, there's been a lot of cases. So in these last few minutes, there's been a lot of cases that SCOTUS has decided. What do you think in all the cases that's been talked about are going to have the biggest ramifications or longest term impact on families? Do you think?
Gosh, I mean, of that list you just
Well, of all of them, because they've done so many, right? We just kind of talked about the recent ones, but there's been a lot.
yeah, I mean Murphy kind of like strikes me because that's fundamental to the access of the internet and all the social media influences upon everybody. I mean, every politician out there has a social media account and they use it to communicate. Even the president of the United States uses it. So, it's part and parcel of our lives. Facebook create the largest nation in the world with its membership, right? Or X, they call it X today. So I'm kind of concerned about not having any, the ability of government to use the social media platforms to go screen and scrub and, you know, restrain people's First Amendment rights of free speech.
Do you think over the last few months, what we've seen with the Supreme Court is they're trying as much as they can to give the power back to the states?
They are. I think they're leaning that way. I think they're going back to the basic notion that the states are the laboratories of democracy. No state has a monopoly on all the wisdom, all the best practices of the nation. I don't think anyone believes that anymore. So I think it's better to allow the states to experiment, given the technology we have today, the changing that's going on so quickly today. Let them experiment and decide amongst their own people through their legislative, policies by their duly elected officials locally in each state.
That's so interesting. All right. So, final thoughts. What encouragement would you give people of faith who they just get so overwhelmed by this legal back and forth? What the Supreme Court says, what it doesn't say, what's happening locally. I mean, how do people of faith stay plugged into all this without going absolutely insane?
Well, I think it's one of those things to know who you are and know your faith. Stand convicted in your faith that there are promises in the good book for all of us every day. I mean, it's one of reassurances. It's one of promise for good. It's one of promise for getting through these hard times. I mean, he didn't say life is going to be hunky dory, right? In this life you have tribulations, but be of good cheer. I have overcome the world.
I love that. It's one of my favorite scriptures.
It is. You know what I mean?
Yeah.
I believe that, right?
Yeah. Do not be afraid. I have overcome.
Yeah, be strong, be courageous.
Yeah.
And he commands us. Why? Because he's going to be there, right? Lean upon me, all of you who are burdened, heavy laden, right? You know what I mean? Rest upon me. I'm going to take care of you.
I'm going to take care.
I'm going to take care.
I'm going to take care. Well, that's the best hands to be in, man. If you're going to be in any hands, there's going to be a lot of things that are going to happen on the Supreme Court level. They always run through their cycles, right? They're almost done with this round, right? And then they're going to start up again in October. Is that how that works?
Yep. So they're done for this session.
They're done for this session. All right. So stay tuned. For the next show, we are going to be having Brad and Esther McDaniel, and they're going to be talking about a recent report that's been released on the foster care system in Hawaii. So stay plugged in for that. Like, share, subscribe, hit that notification bell so you know every time we upload a new video, and we will see all of you next week. Mahalo, everybody.